Okay, the YouTube live is also up and running. The challenge with the YouTube one is that I cannot control when it starts. The moment I send the stream from here, it just gets going.
Okay, no worries.
Just
I'm
3 minutes out. So we will go live. Okay, I think the Facebook is going now. All right. Okay, we are live on both of platforms. We can start the webinar here. Start. Yeah, we got attendees all joining right now. Let me rename you to Attorney Nicole Manifest Law.
okay, no worries.
How was your weekend, Nicole?
Pretty good, pretty relaxing. I will say I tried to, it's not that I'm trying to take it easy. It's more so that, you know, so much has happened, right, Raghu, in like the last few months. There's probably, I wouldn't say more to happen in the next few months, but there's just a lot of information that's always changing every day. So whenever you have those moments of peace, right, I think it's always good to take those moments of peace.
Yep. You never know what new rule is going to be announced or what new changes is going to come.
100%.
And have you started getting any questions about RFEs coming for the 100K and as well as people who are applying for consular processing from outside India? I've been
Yeah, I
noticing.
mean, I will tell you that what I've heard a lot about, which is so some people have gotten RFEs because they filed before the payment mechanism was even put online and they sought for consular notification, and now these RFEs are asking for the 100K payment proof. But the interesting RFEs that I've heard about, I haven't physically seen them yet. Sometimes a lot of attorneys are scared to like share those papers because they're technically confidential. Is actually RFEs about individuals who sought consular notification but already had a valid visa stamp. Because you remember that in one of the guidances that was released by USCIS, they said if you already have a valid stamp, then you are exempted, right? Even if it was from a prior company, even if you've already left the country, you're already outside of it for a year, it's just that your stamp is still valid. People even in that scenario are getting RFEs at this point, and it's unclear if it's because the government in the initial filing didn't have the visa stamp, because it's not required for you to provide a copy of your existing visa stamp, or is it that their records just don't show that they have a visa stamp, so it's unclear like how that's going to be applied. But that's the interesting RFEs that we've seen down the
Okay.
pipeline.
All right. And
Mhm.
for the attendees who are here, I'm just talking with Nicole about the 100K RFEs. But today's session is about EB-1 and how do you get your EB-1 green card? How do you qualify for it, even though if you don't have your PhD? Last week, I did a webinar with one of Manifest Law's client. He is based in Bay Area and how Manifest helped him with his green card process on EB-1. And guess what? He had only masters. He did not have PhD. The replay of that event is available in the Facebook group of Happy Schools. And I believe in Manifest Law's YouTube page as well. At the end of this interview, I will point you to the direction where you can watch one of Manifest Law's client who was able to get EB-1 just with master's degree. So today, this webinar is also sponsored by Manifest Law. I have attorney Nicole. I believe this is our third webinar, right, Nicole, that we are doing?
Yes, it is our third webinar together.
Third webinar. So we are going to break down how does EB-1 green card process works. And we will help you understand, educate you about the process. It may apply to you, it may not apply to you, but having knowledge, you may be able to share with some of your friends. That is what we are hoping for in this free session. Hi, Nicole. Welcome back, and thanks for joining me today.
Yes, so thank you for having me, of course, Raghu, and for everyone watching, thank you for tuning in.
Fantastic. So, Nicole, let's get started with what is EB category? Let's create a baseline for that. How is that different from, say, H1 or O1? And what is an EB employment-based immigration visa category means? Let's educate them about that basics, and then we'll jump into specifically EB1 option.
Sure. So the EB stands for, as you mentioned, employment-based. It's essentially a series of categories that focuses on work-related things here in the United States, but more specifically, what the EB categories are for is pathways of eligibility towards a green card. So how is it different, like you said, compared to the H-1B, to the O-1, and all these other like alphabet soup that makes up immigration? The EB categories are for you to get towards the line for an inevitable green card at the end of that line, right? The thing is that you did already touch upon this. There's different types of EB categories, everything from EB-1 all the way to EB-5. And the topic of today's conversation in particular is one of those special EB categories, which is the EB-1. But it does stand for employment-based, but just because it says employment-based doesn't necessarily mean you need to have employment. I would really think of it as what is it that you're going to be doing to the United States related to your occupation.
Okay, all right. So somebody who is on F1, how does their path look like to get the green card? What are the visa stages they have to go through?
So there's never really like one prescribed pathway, but I'll tell you the most normal pathway. Usually you're on your F1 and then you change into some sort of non-immigrant visa, like the H-1B or the O-1, that allows you to continue working in the United States beyond just the OPT and the STEM OPT that you may get from your F1. However, after you have this H-1B or once you get like this O-1, you don't necessarily want to keep being in this status and keeping to renew these work visas. They cost money. They're usually tied to a specific employer. So then when you're saying, how do I get to the next step, which is the EB-1? So once you're on your H-1B, once you're on your O-1, you have to apply for one of these EB categories. And that's through a form known as an I-140. Of course, there's many different things that you have to do in order to even attempt to file that I-140. But once you've filed for it and it gets approved, then you're in the waiting game towards a green card where you need to file the next stage afterwards, which is called an adjustment of status or a 485 if you're in the US, or consular processing if you're outside of the US. So if you're saying what's the normal path, it's usually F1 to OPT to either an H-1B or an O-1 or some sort of qualifying work visa that you have. And then you get into the green card scenarios by filing the I-140, which is your eligibility for the green card. And then last stage, which is that adjustment of status where you're changing into the green card.
Okay, for employment based, it's typically EB-1, 2, 3, and EB-5, right? Or the
Yes.
EB-4 is not for mostly the audience that we're talking with.
Yeah, EB-4 is definitely like a special category. It's not really discussed that much because it's not really relevant, but it's usually EB-1, 2, 3, and 5.
Okay, got it. And where does O1 visa fit in this category?
So the O1 visa fits in this category as either A, from the OPT instead of the H-1B. If you don't win the lottery or you're not cap exempt, you jump into the O1 instead if you qualify, right? Sometimes the O1 can also fit as after the H-1B, which is that if you run out of time on your H-1B, where there's a 6-year limit and you don't have an approved I-140 or you're not far along enough in your green card process to extend beyond the 6-year limit, that's when you jump into the O1 because that will buy you more time in the United States.
Okay, so from H1 or O1, then comes EB-1, 2, 3, or 5.
Yes.
Or basically EB-1, 2, or 3. EB-5, anybody can do it at any point in time.
Correct. And the way that I think about it is that the EB, let's call it EB2 and EB3, the most common pathways are through employers, right? An employer decides to sponsor you for a green card. Usually that is started in the middle of your H-1B or your O-1 because it takes a long time to get to the point where you have that approved I-140. Right now, for employers to sponsor through what is known as a perm process, you're looking at about a 2-year to maybe even 3-year timeline with the current backlogs.
So perm is for EB-2 and 3 potentially.
Yes.
So that's the labor condition application. That's the first step of the green card process.
That is correct. Essentially, in order to even qualify to file for the I-140 based on this, you have to go through this labor certification process where the employer proves that no US worker can fulfill your role. Once that's proven, after a series of steps and processes, then and only then can your employer file for that I-140.
Okay, so EB-2 and EB-3 has steps like perm, I-140, I-485.
Yes.
Okay, awesome. Now, how does EB-1 fit in this picture? And let's start from that.
So the way that EB-1 fits into this picture is that you get to skip that first step, perm, EB-2, EB-3, right? So whereas the perm itself can take like 2 to 3 years, the EB-1 allows you to go straight into step 2 and immediately file for the I-140 because it's a self-petitioned application. Essentially, you don't need to have a specific employer to sponsor for it. And you also don't need to do that labor certification process because the government is prioritizing these EB-1 applications. They said, oh, we want extraordinary ability individuals, or we want people of this first priority category. So you don't need to prove that there's no US workers to fulfill this role.
Okay, so EB-1 skips perm, which saves about 2 years of the process.
That's correct.
Okay, all right. So how does someone qualify for EB-1, EB-2, or EB-3? Who determines that?
So the government has a few rules, right, about what qualifies for EB-1, 2, and 3. So I'll start first with like EB-2 as a concept. So EB-2 is for people who have advanced knowledge or exceptional ability. So in a perm context, how you end up in EB-2 is whether or not the job that is being proposed for you as part of this process requires at least a bachelor's degree and 5 years of experience to fulfill, or alternatively, at least a master's degree to fulfill. There is also another way through something known as exceptional ability as well for EB-2s. Those are a little bit rarer. There's a series of criteria for it, but I would probably just set that aside first, right?
Okay.
For EB-2, you can also qualify for it through a national interest waiver. You're doing something of national interest, right? You apply for it, you get slotted into EB-2.
Okay.
For EB-3, it just depends on what kind of worker you are. It's anything below, essentially, that what I just said for EB-2.
Okay. And attendees, a quick note for you all here. I am sharing the screen right now. If you're on Zoom, on desktop, it has multiple tabs. One tab is where just the video comes in. On the second tab, you are able to see the screen share where I am having a whiteboard where I'm typing it in. If you're finding this useful, please on the Facebook group, this is live streamed on the F1 Visa group, or you should be able to also invite your friends. Hey, if you're in a WhatsApp group or on your Facebook, please head out there, post the link. I'm also going to post that link on the chat here so that your friends can hop into this call, because what I think what we are sharing is something that most of you may not know about this. So we want to educate you as much as possible. You can share the Zoom link with your friends. They can all hop in to listen to this. All right. So we touched upon EB-1. Within EB-1, Nicole, we have subcategories. What are those and how does one qualify for those subcategories?
So for EB-2, I'm sorry, or EB-1? I didn't catch
EB-1.
that. EB-1, yeah. So there's 3 subcategories in the EB-1 category. There's EB-1A, which is the topic of today's conversation, EB-1B, and EB-1C. So for EB-1A, it's extraordinary ability. You are a person who is at the very top of their field. You have extraordinary achievements. So that's why the government gives you this priority pathway for a green card, to put it simply. For EB-1B, you're an outstanding professor or researcher, whether you're working for a public or a private institution, and an employer is sponsoring you as that outstanding researcher or professor. There's also certain requirements for it, of course, but that's generally what it is. The EB-1C is for multinational executives. Essentially, you are being transferred from a foreign entity to the related US entity in that senior position, and you've held senior positions in both of those organizations. So to put it very simply, if I was working for Citi in Singapore, right? And I worked as a director there, and I'm being transferred to the United States to be a director at Citi in New York. That would be what the government would consider as a potential EB-1C here.
Okay, all right. So let's narrow down to EB-1A and dive deeper into how does one qualify for EB-1A, and let's talk about that.
For sure. So EB-1A, well, how I try to explain to people in terms of how you can qualify is that there's two stages of review that you have to essentially overcome. The first stage of review is something known as the criterion analysis. The government has a list of at least essentially 10 criteria. There's a hidden 11th one known as comparable evidence, but what's actually listed is 10 criteria. You need to meet at least 3 of those criteria to essentially pass that first stage of review. The second stage of review is something known as the final merits determination. So after you've met at least 3 criteria, the government allows the officer to make a judgment call. They say, hey, officer, do you believe that this person is truly someone who has sustained national or international acclaim in their field? Vis-a-vis, is this someone that truly is at the very top of their field, right? So that's the two essentially buckets of requirements to pass the EB-1A. You need at least 3 of that 10 category, and you also need to make the officer believe that you are truly someone who is at the very top of their field.
Okay. In the interview I did with your clients last week, he went through a route of O1 and EB-1. So how does somebody who does not have a PhD get from OPT to H1, then O1, or OPT to O1, then to EB-1? How does the path look like?
So I will tell you that when you're on your F1, you want to start as early as possible developing or investing into the right opportunities that would set you up for success for the O1, right? Now, the earliest you can start, in my point of view, is actually your junior year of college. But don't fret, even if you haven't started that early, most of the bulk of the work actually occurs during your OPT. So what do I even mean by bulk of the work? The government lists out these criteria, and they already tell you ahead of time you need to meet at least 3. The O1 works very similarly, except instead of 10 criteria, there's 8 for the O1A and 6 for the O1B. You have to look at that list and identify which criteria you think you can start building towards. And you start doing activities, or you start doing things to start fulfilling those categories, right? If you're here on a STEM degree, you will have a 3-year runway to start doing these things. If you're on regular OPT and you don't qualify for STEM, that's where things get a little bit trickier. It's not impossible because the barrier of entry or the requirements for the O1 are definitely less than the EB-1. There's no final merits call for it. But that's the pathing. On OPT, you need to start investing your time in building towards the evidence for those 3 criteria. Naturally, in building towards the EB-1, you're actually also building towards the O1. So if you don't win the lottery during the OPT, it is normal for people to say, since I've already started doing stuff for the EB-1, I think I can qualify for the O1 to buy myself more time. And then once you're on the O1, again, doing more opportunities so that you have a stronger EB-1A case to file.
Okay. And if someone qualifies for O1,
Yeah.
and for the audience, for you to understand how the O1 visa works, I did an hour-long session with Nicole a couple of weeks back. That replay is available on the Facebook group and as well as on Happy School's YouTube page as well. And I believe it's on also Manifest Laws YouTube channel as well. Please go and check an hour-long session about O1 visa, the criteria for that, and how do you qualify. So now, if somebody has O1, they qualified for it, how does that translate into EB-1A?
So the way that it translates to the EB-1A, because I think I mentioned like once you have the O1, you need to build a little bit more, right? The perspective is that the O1, while it is similar to the EB-1A, is not the same. It's not the same because the EB-1A has a higher standard. So when it comes to, hey, Nicole, how do I transition? Spend more time, maybe another year, right? In terms of getting more evidence to overcome final merits. Because now you know for a fact, you're probably going to meet at least 3 criteria. It's a good litmus test if you already have an O1, right? And everything that you do thereafter is to target that feeling of the officer saying, hey, I do genuinely believe that this person is actually at the very top of the field, right? So whereas, let's say, I want to give an example. Let's say it's judging. You did peer review, right? You've done your peer review. Is peer review still enough? Is it going to be that you just do 10 peer review and that worked for the O1, that's going to work for the EB-1A? No, you should continue to do peer review. Maybe for bigger journals, well-known journals, or maybe different kinds of technical publishers. Or is it that in leveraging your peer review experience, you become a session chair for a conference, right? That suddenly elevates your profile more. So that transition 100% is just building more evidence, but at an elevated scale by the time you're moving towards the EB-1A.
Okay, all right, sounds good. So let's take a question from Anthony. How can a petitioner, a PhD student, or an early career researcher with low publications and citations effectively demonstrate sustained national or international acclaim? And what type of evidence best show that they belong to a small percentage of individuals at the very top of their field?
Right. So I will say that if you're on the early career researcher track or you are still a PhD student, what it depends on is, did you have a career before you became a PhD student, right? Because sometimes people are, they have their bachelor's degree, they work a few years in the industry, right? Or they get their master's, work a few years, and then they decide to do a PhD. So that's usually the first question I ask. Because if you already have professional works, let's call it, or a career before you became a PhD, then that question of sustained acclaim doesn't start from the moment that you're a PhD student. You can go back in time and say, well, no, I've been excellent. It's just that I decided to go back to school to invest my time in new opportunities and the like. That's one. But if that is not the case and you're this early career, then I would challenge you to say, don't drive immediately for the EB-1A. You really should be considering, do I need more time and build into the O1, where this whole entire notion of being truly, madly, deeply at the very top of your field with the subjective judgment call is going to hurt you because you're still a recent graduate or an early career researcher. Do not get me wrong, the O1 still asks that question of whether or not you sustain a level of acclaim, but it's not to the degree of hardship as the EB-1A does.
Okay, got it. Anthony, if you have another question, you can raise your hand. I will give you access to your microphone. You can quickly ask 1 or 2 follow-up questions. Next question from Sparsh. How many citations or H index should generally be required to qualify for EB-1A?
There's actually no requirement to have a certain number of citations, let alone an H index. Now, when it comes to H index, obviously the more impactful the actual publication is, the better it is. There's no question that if you're like a biologist and you've been published in Nature, that is worth its weight in gold compared to 10 publications that are out there that have a really low H index, right? Do not get me wrong. But it's all about a matter of perspective. If you're in a very practical field, let's say you're an engineer, a traditional notion of engineer, then citations and H index are actually not as impactful as you think, because you work in a very practical field that's not known for progressive research. So even if you publish, a lot of the times people who think your work is innovative and novel, they don't implement it in their own research. They actually implement it in a real life setting. Hey, he figured out something cool. He figured out something innovative. I'm going to do it in my own work, right? In my workplace. So when you ask me how many citations or ingest is generally required to qualify, there's no rule. There's no benchmark even, right? I've had a variety of cases with 0 citations get approved, right? And also cases who have 2,000 citations get approved, right? What actually matters is when you look at the criteria, do you meet the criteria? And can you say convincingly to an officer that you are somebody who's at the top of their field or distinguishable from all of the others who may be in that stack of applications that they're reviewing?
Okay. You mentioned, Nicole, that EB-1A is self-petition based application. What does it mean? How does it differ from an employer petitioned application?
So self-petition means that you can apply for it by yourself. You don't need an employer. You can lead the application as essentially the petitioner and beneficiary, but it's really as an applicant, right? How that differs from an employer-sponsored petition is that in an employer-sponsored petition, they're the ones filing on your behalf. They're the ones signing the paperwork saying that I am petitioning for this individual. And usually in those scenarios, you have less control over the product that you are submitting with USCIS. Take, for example, if you did an employer petitioned EB-2 NIW. So instead of you applying directly with USCIS, the employer is the one who is usually accumulating the documents, making the argument, and submitting it because it's their petition for you. So I do encourage people to consider self-petitions because you maintain that control. You are the driver of that car, right? And you can form the application in the way that makes you feel comfortable and also exemplifies and sells what makes you so special and distinguishable.
Okay. And for the attendees, please continue to post your questions on the Q&A tab. And there are limited opportunities. If you raise your hand, you can speak up and ask your questions through your microphone. Trust me, you will not be on the video, so you don't have to go around to make yourself look good, okay? Just the microphone. So how does manifest law come into this picture? If, let's say, a person is thinking, I want to see if I'm eligible for O1 or am I eligible for EB-1A, and self-petition is possible. Can manifest law help such folks?
Of course, right? We have a very strong evaluations process, right? Where essentially when you come in and you submit information, it's not like we're not going to do a consultation because you haven't even met the criteria or anything like that, right? We'll even tell you on the consultation, hey, this is what's a little bit weak. These are some of the things that you should be considering and investing your time into, or try our best to build a roadmap. But I can do you one better, Raghu. A lot of what Manifest does, which I think is really cool compared to a lot of other firms that are out there, is that we do provide services to give you the advice that you need in order to build that roadmap. We have an opportunity matching program. Hey, I need to figure out how to do judging. I need to figure out how to qualify for this. What can I do? Here are some opportunities that you should be doing and applying for, and here's how. Right. So that's what Manifest does. Not only the evaluation, we really do try to build that roadmap for you.
Okay, fantastic. Next question from Shaurya. I have master's and I'm a BI engineer profile and I'm on H1B. Am I applicable?
You know, what I will tell you is that when people tell me like, hey, I have this master's degree and I have an engineering profile, an H1B, it comes across to me that their concern is that I don't have a PhD, right? It's like, I don't have a PhD. I'm also not an AI engineer, right? Who is getting paid $1 million by OpenAI to exist and like do stuff, right? That's innovative. So the answer to the question here in terms of whether it's applicable is that it depends on whether or not you meet the criteria at the end of the day. The government doesn't care if you have a bachelor's degree or a master's degree or a PhD. They don't even care if you don't have any degrees, right? I think what matters is that do you have the achievements? Do you have the evidence to qualify in one of the categories that the government has described, right? So if you are a BI engineer, that's great. try to find, like, if that's your niche, if there's a way for you to establish like what parts of that engineering field is different about you than others. But there's nothing there that tells me that you wouldn't be able to qualify, to be clear.
Okay, all right, fantastic. So I'm going to give access to Rohan for you to ask the question to Nicole. Please be mindful because it's a public session. This is recorded. So don't ask any questions that are very personal to you. And the advice that Nicole gives is of generic in nature. All right. So having told the disclaimer, Rohan, you can unmute
Hey,
yourself. And what's your question, Rohan?
hey, hi, Nicole. So my question is like you were mentioning filing EB-1 or O1. I follow the news what immigration website has. So EB-1 shows that their current date is 1st April 2022, and O1 is I think having something 2025 only, I guess. So basically. Which one will be the better option for me? EB-1, because I think I need to wait for that to get the current date and then, get the authorization to work. I'm not sure. I'm like, I need clarity between
So,
which
Rohan,
is
I got your
good.
question,
Yeah,
okay? I
yeah,
think,
yeah,
Nicole, we might have to go a step back and explain about the waiting times of EB green card. And I think he's confusing between O1 and EB1. So probably we might have to educate them about why is there a visa bulletin that exists? Why is there a 2 year wait time for EB1? And differentiate that with what is O1.
yeah.
Okay.
Thank you.
So Rohan, what Rohan was talking about, oh, I see that the date for the EB-1 is April of 2023. It's referencing something known as a visa bulletin. All right. So the visa bulletin is this document or this web page, let's say, that gets published every single month by the Department of State. It's published in the middle of the month, usually on the 15th, to talk about the following month. So if it's November 15th, they usually publish it for December, right?
Yeah.
Now, the purpose of the visa bulletin is to tell people when are you eligible to file for an adjustment of status, right? Or proceed with the next steps of a consular process. Because the adjustment of status is where, as I remind everybody, is where you tell the government that I want to change my status, let's say I'm on an H-1B, right, into a
Yeah.
green card. The reason why this visa bulletin is published is because every year there is a limit to how many green cards can be issued in a given fiscal year. Now, that limit is actually pretty low compared to the number of people who are interested in getting a green card. So, because of that, they published this visa bulletin to push these cutoff dates to prevent people from filing that adjustment of status because they've started to run out of numbers per year. So, when I'm looking at this visa bulletin, I'm going to see if I can click on these things, but it's a very, very odd concept. Essentially, the reason why China and India for EB-1 say these cutoff dates, they say, you can only file your green card, like the last step, if you filed it before the 22nd of December 2022 for China and before the 15th of February 2022 for India, right? Essentially, it's because they're the highest volume countries of immigrants. Because in addition to that annual limit of the number of green cards that they can issue, there are per country limits, right? So each country is only given 7% at max of the number. I think it's about 9,800 green cards per year, right? For that particular country. So that's the reason why the visa bulletin exists, right? It exists primarily because there are more people who want green cards than the number of people that exist, right? The numbers that exist to give these green cards out.
Sure.
So yeah,
You
it's
can
complicated.
quickly talk about 140,000 employment based. So, and then we can tell them how the 9,000 or so number came into picture.
The 9,000 came into the picture because only 7% of these visa numbers can be allotted on a per country basis, right? So because of that, that's why India and China have really large wait times compared to the rest of the world, is because those visa slots fill up fastest for high volume countries. Both China and India have the largest population, right? Population size. So of course, 9,800 is not even close to being enough compared to a country like Mexico or the country like the Philippines or a country or any of the other countries that are not even listed.
Okay. And what does C here mean, Nicole?
It means current. It means that there are visa numbers immediately available. So once you file that I-140, where you prove that you're eligible for the EB-1, you can actually immediately file for the adjustment of status because a number or a card is available for issuance for your country birth.
How does this date is linked to an individual application, the priority
Right.
date? So could you explain what priority date is so people can understand, okay, this is my date and how do I check in relevant to this one?
Right. So a priority date is, depending on the application, the date that you file your I-140, right? Or if it's in a perm context, the date that you filed for the perm certification. You usually can find your priority date on your I-140 receipt notice or the approval notice. The way that I would think about it is like the DMV. When you go to the DMV and you show up, you get a ticket. It says like A100. And the earlier that you show up to the DMV and you get that ticket, the earlier your number is going to be called, right? So the priority date is that ticket, that number that you got in the queue, right? A100. The cutoff date on the visa bulletin is that big screen at the DMV that calls up your number. So the moment that A100 is called, which is this date, or anything that's before it, you get to go up to the front of the window and finish your process to get your driver's license. But in this case, it's your green card.
Sure.
Right? So that's how you find it. And
The
how
person who is coming late can see the board and then think, I don't have my number yet, but current now person who has A100 is being served. They go pick up the ticket, which is your priority date, and it shows A200, which means there are 200 people in front of you. And so that is a way that you can think of this one. Thank you for the explanation, Nicole. I think there are a lot of questions. Let's get to some of those questions. Rohan, does that answer your question?
Yeah, so this EB-1, so say now 22 is going, if I file EB-1 now, so it's going to take a couple of more years. Can I work during time before getting into green card or not?
No, because when you apply for an EB-1A, the only thing that you get out of it when you get the I-140 approved is that you have proven that you are eligible for the green card. It doesn't give you work authorization on its own. You would need to either have that H-1B maintained or an O-1 maintained, right? Or some sort of working visa that allows you to keep working. Because the only time you get work authorization based out of that EB-1 is when you're able to file that adjustment of status paperwork and request for work authorization. And that's precisely why the visa bulletin exists, is because you can't get that work authorization until many years into the future when you are eligible to file that last stage.
And Rohan, one more thing for you to remember, it is not if that date, what you are seeing is December 22, 2022, it doesn't equate to exact translation of my wait time is going to be only 3 years.
Right,
Okay.
right.
The next visa bulletin, that date could become current. Essentially, the A100 could essentially become A200 because they
Right,
had
right.
100 new officers came to serve you. So it
Yeah.
is not like a one-on-one date way to think.
Yeah.
Okay.
Yeah, waiting time could be anything, but yeah, I mean, just to follow this. This is this applicable to self-sponsor EB also or no?
Yes, the wait
Okay.
times are for anybody that's on that first category, right? And then
Okay.
you know how it says 1, 2, 3, and 4? That's tied 100% to EB-1, EB-2,
Okay.
EB-3.
Thank you, Rohan.
Thank you. Thank you.
We'll
Yeah,
go on to the next
thanks.
one. Okay. So, Nicole, another question from Debo Mitra. Is it necessary to have articles published about your work or yourself in leading media publications?
Not necessarily. I will tell people that industry and trade publications can be equally as powerful, even if they don't have millions of subscribers, right? There's something to be said that if you are a battery engineer or an energy specialist and you get published in like Power magazine, right? Which doesn't have the largest circulation in the world, but it's an industry publication. It's one that is very well respected within that field, right? Another example that I would give to people is if you're in fintech and you get published in payments.com, that's pretty relevant. It's not CNN, it's not the New York Times, but it can be extremely helpful.
Got it. Okay. Attendees, there are about 25 questions on the Q&A tab. You have now the ability to read those questions and vote for the questions that you want answers to. So I'm going to be asking Nicole the questions that is at top of the list, which is most frequently asked question. In that way, instead of me sorting through a long list, you guys are helping us to ask the most important question that you feel we have to answer it for you. Okay. In meantime, while you do that, Murugesh, what question do you have for Nicole?
So what I'm asking is, one of the question I had is, I'm in a structural engineering field. Can you guys hear me?
Yes.
Okay.
Mhm.
So I'm in a structural engineering field, and very few people, they pass SE exam. And that's one of the exams that's allow you to design high-rise buildings and all of that. So, and very few people in the United States pass this exam. So does that kind of like we can consider as a one of the criteria? And also one of the point I have is, let's say if I'm at a really good position in my company, like depend now which company you're talking about. If it's really like Amazon or Google, I'm not talking about those, but let's say if my company dealing $300 million per year and I'm at the vice president position of engineering, does that kind of like helps, or is it kind of like does not help?
Okay. So the first part where you're saying, is an exam enough? I think the follow-up question that I would probably ask is, are there other components that you have to do in order to get this licensure, or is it only just the exam, right? Is it that you needed to be nominated to even take the exam, or is it after that you've passed the exam, there's like a whole interviewing and vetting process? Because to be honest with you, Mukesh, like the government's perspective for associations, like you're a member of something that's exclusive out there, cannot just be an exam. It has to be this huge vetting process where essentially there's like an interview, there's something that makes it just harder than passing a test, because passing a test, I know that it could be hard. It could be that only 5% of people pass, right? But their perspective is that then that person only needs to study really, really hard, maybe graduated with a certain degree, right, in order to technically qualify for it. It needs to feel much more exclusive than that. In terms of like your second question, where you're asking me about your role in VP, like titles can be helpful, but what's actually more meaningful is truly madly deeply, can you prove that you're in a leadership position? Let's say you're overseeing people. Can you prove that you're overseeing those people? Or that you're doing something that's critical for the company? Because I could tell somebody that I'm a CTO. Raghu, I'm CTO of my company, right? But the title doesn't matter if I can't prove that I'm truly a CTO, that I'm doing tech related stuff. Trust me, you don't want me to be anybody's CTO. It's
So
going to be foresight.
probably like the company structure, let's say how many employees works in the company and how many people works under me, and probably the letter from the CEO describing my role and how important I'm a
Murugesh, I think we are getting into your specific case.
Okay,
Why don't
sure.
you schedule a call with Manifest Law, and
Sure.
Nicole can, or somebody from their team can walk you through the process. All right?
Sure. No problem.
Fantastic. Thank you, man. All right. Let's go to next question. Siddharth is asking, how long does it take after filing to get a green card?
So once you file for, and I assume this is the 485 stage, right? Once you file, I feel like lately, Raghu, I've seen such a mixed bag. I've seen people get approved in like 4 to 6 months with the green card in hand, but I've also seen people have to wait like a year to a year and a half, right? There's two reasons why it can be varied. Number one is that nowadays the government is asking for interviews. In the past, if you did like the employment-based categories, the odds of you being called for an interview are like close to zero. Like it was extraordinarily rare. But because of the increased compliance and vetting processes that is being enforced right now under the current administration, there have been more calls to an interview. So when there is that call for an interview, unfortunately, you're beholden to the next available appointment at your field office. It doesn't help that we have a government shutdown, much less limited funding. It's true that USCIS is not as impacted, but it doesn't help. It doesn't help. The second reason why you could see some of those delays is because I'm not going to get too deep into the legalese for the visa bulletin. There's the filing date and there's the final action date. So it is possible that you can file the adjustment and you're allowed to have it pending, get all the benefits of work authorization while it's waiting, but they will not issue you the green card until you're also current for the final action dates chart.
Sure. I think looking at the questions here, Nicole, maybe we can have another webinar just to talk about the basis of visa bulletin.
Yeah.
EB-1 priority dates, the final action dates, 485, EAD, AP. Probably we can have a session just for that. So question from Lokesh. What if someone, let's say, currently has I-140 under EB-2, and if that person becomes eligible for EB-1 and file for it, so the original priority date from EB-2 can that be used for EB-1, I-140 and 485?
Yes, you can absorb the priority date. So if you already have an EB-2 approved with an I-140, right, that's the approval, and you have a priority date for that in the past, when you file for the EB-1A, EB-1B, EB-1C, you can tell the government you want to take that priority date.
Okay. Another question from Akshat Dev. I'm on H4 visa. I would like to explore O1 and EB-1 green card. Would I be qualified? I have master's degree and 7 years of experience in India in IT field. So Akshat, please schedule a call, go to Manifest Law, search, Google them. You should be able to find. Do you offer free consulting for the initial call? How do you do if somebody from this call, they want to reach out to you?
So I will say we generally do provide free consultations. The only time where maybe a consultation could be paid is if you have an extremely complex case. If you're coming to me and you're like criminality, or you have a waiver related issue, or like a really strong like legal question that isn't a normal analysis, that's where it doesn't really happen. But generally our consultations are free.
Okay. On the same lines, question from Manoj. Where can I find the estimates for evaluation with Manifest Law? Is there a free consultation, or is there a fee to evaluate if I'm eligible for EB-1A self-petition?
Our consultations are generally free, right? The only limited exception is if you have an extremely complicated history, right? And we'll tell you that upfront. I think the most that we charge for a consultation ever is $349, and it's refundable.
Okay. Question from Samir. Hey, Samir, you are able to speak up. Please unmute yourself and ask your question. You there, Samir? Okay, I have your question here, but I'm going to just hold on to it until there you are.
Yes. Yeah. Hi, thank you for this time, and thank you, Nicole. So currently, I'm a district manager for Burger King, and I'm working for a franchise. And I've done my master's from US only. And so I don't know if, and again, I heard in all this the call that you can have a free one first consultation. You can just go. I don't know if I'm eligible for O1, and but I do have a past experience. I have a 15 almost 2 decades of work experience, 15 years in India and around 6 to 7 years in US. So I don't know which category I fall into and how it will work for me. as an individual?
So let me give you a recommendation in terms of like, how can I even start considering the O1? Like, why would I even consider the O1, right?
Yeah.
I'm a little bit different from other attorneys where I actually encourage people to use like online resources. I always tell people
Okay.
like the world is your oyster because of the internet, right? It's brought people closer together and it's also brought knowledge closer together. ChatGPT and Perplexity, those tools are like your best friend, right? Put together your resume. Like literally, like take the time to actually put together a full CV of everything that you've done. Because you're telling me you have 20 years of experience, 7 years of experience. You need to break down everything that you've done,
Okay.
right? You were not even just applying for a job, but you need to tell everybody about anything that you've ever done that is mildly considered an achievement, right?
Got it.
Plug it into GPT and basically ask it, tell it to take the role of an immigration attorney or a USCIS officer and say, how would you break down my achievements and my background into the criteria, right? Now,
Okay.
don't take GPT's word for it. I'm not telling you to say to use it as replacement for legal advice. However, it will tell you a general idea of at least like, do you even have something to talk about? Right? Is it even relevant for you to even consider the O1? Separately, you can even ask like GPT and these online tools, like what does an O1 even look like? Like what are the requirements? Because the purpose of today's call wasn't to list out all the different requirements that are out there, right?
All right.
We have a webinar for that, right? We also have a lot of online resources on Manifest's website to show you what these criteria means, right?
Mm-hmm.
But start with that because you just gave me like the TLDR. Like you gave me like an overall summary, but it's hard for me to
Correct.
say you're qualified. But if you have that wealth of experience, start to unpack it. And that's going to be your starting point.
Okay.
Okay.
All right. Yeah.
Thank you.
Thanks a lot. And yes, and I will do that, and I will reach out to your company once I have something relevant to talk about.
100%.
Okay. All right. Thank you.
Question from Jeffy. Do patents qualify as evidence of original contribution for EB-1? Does patent need to be fully granted or is it pending patent also acceptable?
This is an interesting one because there's a lot of split within our community about this. But I'll tell you this, patents are really good. They're really good in that category because they're original in nature, right? The fact that you're even eligible to file for a patent or you have a granted patent means that it's original. Fine. Easy to prove that part. The hard part is the whole, like, is it like a major contribution? Is it a significant contribution to your field? Like, what is the impact? So if you have a granted patent, it's good evidence, but if and only if you can prove, was there adoption? How was it utilized? Please take a look at the patent citations section on Google Patents. If you scroll down, you can actually see if other companies or other individuals cited to your patent, or if a patent examiner actually said that your patent should have been cited by another patent. Because that's how you show the domino effect of your work. Because if another patent cites to you, that's lawful derivation. They derive something or they evolve something, right? And if you see big listed companies, like AT&T, if they're in telecommunications, right? Or Netflix or all like Apple and the like, that should start setting off bells to you like, hey, so maybe my work did evolve. How did it evolve? Who do I need to reach out to? You click on that patent, you'll find the innovators for that patent, right? Or the inventors, sorry. You cold email them. The worst thing that can happen is that they don't answer you or they say no, but you never know if they're willing to just say like, yeah, no, you had a really cool patent. We cited to it because of X, Y, and Z.
Okay.
But yeah.
Ashfaq, your question is next. Are you able to unmute yourself? While he is getting there, question from Anup. Can I take necessary steps to become eligible for EB-1 or O1 from Canada? And can I still apply? Does it help if I lived in the USA for more than 10 years, have 2 master's degree in the US and experience, but right now living in Canada?
So there's no one preventing you from applying for an O1 or an EB-1 when you're outside of the country. A lot of people do get approved when you're outside of the United States. It also doesn't really matter if you've lived in the US in the past or even if you have 2 master's degrees, right? I actually think one thing to consider is that at the end of the day, US-based achievements are always fantastic. It's easier for the officer to understand what they are, but don't degrade your international achievements. There's probably a lot of things that you've done in Canada or any other country that you lived in that could help you qualify.
Okay, got it.
I can ask my question now.
Yeah, please go on.
Hey, thank you so much for organizing this. One quick question. So in EB-1A,
Right.
first of all, if someone is on OPT and considering EB-1A, what is the burden of proof? Like, do they need to prove that they are people with exceptional ability or given or meeting like with focus on the criteria that you mentioned, or does their work or the proposed endeavor have to be related to their current work? The other question is, or if I say it another way, does the proposed endeavor in EB-1A have to be different, or can it be different from what you would have in, let's say, EB-2 NIW?
Okay, so here's the thing. You're mixing up a lot of different terms and concepts that are established in the EB-2 NIW and not terms that are used in the EB-1A. So I'm going to break this down. You mentioned exceptional ability. Exceptional ability is a standard that applies in the EB-2 front and doesn't apply in the EB-1A front. EB-1A is extraordinary ability. So you have to prove that you're at the very top of your field. Being exceptional is one thing in the eyes of the government. It means that you've met like certain criteria that are established on the EB-2, right? It's like 2 or is it 3 out of like 6 things that they establish, right? For the EB-1A, it's like, no. You can meet all this criteria, but you need to definitely prove that you're at the very top of your field and that you've sustained this international and national acclaim. That is not a requirement on EB-2. Then you mentioned proposed endeavor. So in the EB-2NIW, yes, you have to declare that you're doing something that is of national interest. That is your proposed endeavor. This is what I'm going to be doing. In the EB-1A, all they're looking for is affirmations that you're going to be working in the same field, right, as what you declare yourself to be extraordinary. Because if you tell somebody, I'm an extraordinary singer, right, I've won Grammy Awards and all this kind of stuff, right, you can't suddenly tell them that you're going to work as a graphic designer or you're going to be a software engineer on this green card. That's not the point of the EB-1A. You're supposed to be continuing to be in your field, right? So when you're mentioning these topics, I think always remember that the EB-2NIW is very different from the EB-1A. There isn't, in my point of view, a strong overlap. There are certain materials that you can probably use from your NIW, certain recommendation letters, certain evidences that you've collected to show that you were well positioned that can be used in an EB-1A, but these are 2 very different applications.
Got it?
Thank you.
Awesome, man. Thank you. Thank you for joining. And I shared the link on the chat if somebody wants to schedule a consultation to evaluate if you are eligible or how can you become eligible. I posted the link on the chat, manifestlaw.com/happy schools, so that they can track that the referral came from this webinar. All right. Or if you're going directly to Manifest Law requesting a consulting, just find a place to mention you watched this interview so that they can know that what we are doing is reaching out to more people. There are a lot of questions, Nicole. It follows the format. I have this experience. This is my background. Why? Am I eligible or not? The flavors of that are in different fields: architect, teacher, software engineers. So what would you want them to do? Schedule a call with your team so they can evaluate, correct?
100%, of course, right? I want you to schedule a call. At the end of the day, the best people to tell you whether or not you have a good profile, you have good elements, is an attorney, right? But I want to take a step back because obviously many of you are going to think I'm biased, right? Obviously, run a firm. It benefits me for you to have these conversations. So before you even consider the consultation, do what I suggested earlier, right? There's so many online resources and tools. You can go on the ChatGPTs of the world, or you can even manually do this. Just open a spreadsheet, guys. The one thing that attorneys love or professionals love is when you show up with a spreadsheet and you're like, hey, I collated a lot of my achievements, right? Can you just take a look at everything that I've done here as I've organized it under each criteria, and tell me very quickly, like yes, no, weak, no, because at the end of the day, a consultation at best is like 30 minutes to an hour long, right? You want to use up that time to the best of your ability. So to make it efficient, start organizing your materials, guys, because we'll review that spreadsheet. We'll take a look at the compilation that was made by the chat GPTs of the world, right? Just take the time to prepare for it. And in preparing for it, you can decide, is it worthwhile for me to even go to an appointment? Or should I be spending more time seeing what opportunities are out there to develop a better profile before I start investing my time in working with an attorney?
Okay, fantastic. I think I have another interesting question from Samuel. Thanks for the insight so far. After my PhD and postdoc, I joined an IT firm for the past 3 years. Can I still qualify for EB-1? I have several publications and citations during my PhD and postdoc. What are my chances?
The chances question, right? So a lot of the times when somebody comes to me, a lot of the answer, or like not even the answer, the question that they ask is, Nicole, what are my odds? Is it like 80%, 90%, 100%? It's actually really hard to pinpoint in an EB-1A, because even for someone who has the best of everything, right? Like they're the best in the industry, they have all these approvals, they have all of these like achievements, right? The EB-1A has that final merits determination where it's a subjective, in a way, judgment call by the officer. So even in the best case scenario, there's always that risk of a denial, right? Or a risk of that RFE. So what I will tell this particular person is that obviously with more criteria or with higher achievements, the odds are much more in your favor. If you're in the IT consulting field, I'll tell you from experience, the hardest part of your role is getting the proof that you need that you've done something significant. Because the role of the consultant is not to be the front-facing achievements person, right? You're probably fueling the back end of the Googles of the world, right? But they're not going to publicly acknowledge it for you. And the other aspect as an IT consultant that can be difficult is that your consulting company may not be famous. It may not be a distinguished organization, even if you're being seconded or assigned to work for some of the biggest institutions in the world. So be careful. When you're in the IT consulting field, you actually may have a harder time collecting the evidence. And that's the reason why it may matter for you compared to others to meet with an attorney, because we really know how consultants need to collect the right pieces to bridge that gap that is a little bit farther than traditional engineers working directly at the firms that sponsor them.
Okay. Another question. My company have started my green card process under EB-2. Am I allowed to come and talk with Manifest Law? One. Number two, once I get my priority date through my employer, can that date be used for EB-1A?
I'm going to answer the easier question first and then the harder one. So the second one, can you use the priority date after the EB-2 has been approved? The answer is yes. We can absorb that priority date through filing that EB-1 and telling the government that you already have that priority date by showing that approval notice. But for your other question, without kind of getting into like the depths of like the different variations and scenarios, you have to be careful about rocking the boat, is what I say. You got to check your company's policies. What if they're allowed to pull out of your green card process because you started a different green card process? A lot of employees that I've met don't even realize that there are visa-specific policies in their handbooks. So take a look at that, right? It is also always helpful to have the cooperation of your employer, because you can tell them, like, I'm not asking you to pay for it. I'm not asking you to like actually financially support it. I'm just telling you that I'm doing this on my own, right? That does depend on your relationship with your employer. Some employers don't like the idea that you're trying to get a faster green card, right? Or that you're doing your own process. So if you find that there's an employer who may not be the most cooperative, I will tell you first, determine whether or not there's any policies against it. Make a reasonable judgment call if it's a good idea for you to proceed, because there's nothing legally preventing you from filing your own EB-1.
Okay. How are we on time, Nicole? There are a few more questions, but most of them are repeated.
I will probably answer maybe like another one, and then
Okay.
unfortunately I do have to jump off today.
Sure, no problem. Let's go. a simple basic question. I don't have any publications. I don't have a PhD. I'm just a regular software engineer guy. Is there any chance at all for me to qualify for O1 or even think EB1 is a possibility for me?
Oh, you know why I love this question? I think it's because there's a cultural component to people who are from outside the United States, right? And this is something that I know about myself. So for all of you, even though I was born in the United States, very fortunate for that in many different reasons, I was actually raised abroad. I'm Indonesian. I spent most of my youth in Jakarta for the most part. I think we come from a position of modesty. I think as foreigners, we always feel like whatever it is that we do is never enough because we're not the OpenAI guys. Right? Like I've met people who are like some of the key individuals who have built like the underlying frameworks of Google Cloud and Google DeepMind, and they're like, oh, you know, I have these years of experience. I'm just a regular software developer. And I'm like, what are you talking about? Right? When I look at your resume, you have all of these accolades. Oh, but Nicole, I don't work for OpenAI. I don't work for these people. I'm not making $1 million a year, right? So whenever I say those questions of like, I'm just like a regular SDE, I don't have citations. Well, a lot of highly achieved people are technically SDEs, right? They also have 0 citations because it's a field that's not really known for doing research like biologists and chemists and certain doctors do, right? So don't sell yourself short. You won't know if there's 0 chance unless you actually try it, right? Like do what it is that I said earlier, like try to collate the things that you've done. Even the smallest of projects that are just really, really cool can be so niche that it does come across as an achievement. Certain open source projects are that impactful for other people out there. So don't sell yourself short. Because whenever I hear that term, like I'm just a regular SDE, well, everyone who applied for an EB-1A at some point was a regular SDE, right? And then they decided to take the time that they need to invest in the right places to get themselves to the point where, yeah, you are extraordinary.
Got it. All right. Thank you, Nicole. I know there are some more questions that are left, but going through those questions, I feel that we have covered your questions in the past hour that we've been talking here. Please, I will be sending an email with the links to the previous webinars about O1 qualification, about how one of Nicole's client from Manifest Law and how Manifest Law helped him with the EB1 process, and all the previous webinars that we have done. We are looking forward for hosting you another webinar, maybe a simple topic, 101 green card 101, and explain you much more in depth about all the priority dates and whatnot. Thank you all for joining. I will see you again on another webinar. Nicole, thank you. Have a good evening.
All right. Thanks everyone for having me.
Take care, everyone. Bye-bye. I'll just typically wait for a few more seconds because Facebook is delayed.
No, I understand.
Yeah, so I disconnect it right now, and then it cuts off right away when we turn it off, but it doesn't get that we are delayed. All right. Thanks a lot, Nicole, and we will see you again.
All right. Take care. Bye.
Bye-bye. All right. Thank you, everyone. Appreciate you all for joining.